Provisions relating to hazardous process under the Factories Act 1948. Chapter 4A. Provisions relating to hazardous processes. Section 41A to 41H. Section 41A. Constitution of Site Appraisal Committees. Section 41B. Compulsory disclosure of information by the occupier. Section 41C. Specific responsibility of the occupier in relation to hazardous processes. Section 41D. Power of central government to appoint inquiry committee. Section 41E. Emergency standards. Section 41F. Permissible limits of exposure of chemical and toxic substances. Section 41G. Workers' participation in safety management. Section 41H. Right of workers to warn about imminent danger. Let us discuss the sections in details. Section 41A. Constitution of Site Appraisal Committees. Subsection 1. The state government may, for purposes of advising it to consider applications for grant of permission for the initial location of a factory involving a hazardous process, or for the expansion of any such factory, appoint a site appraisal committee consisting of a. The chief inspector of the state, who shall be its chairman. B. A representative of the Central Board for the Prevention and Control of Water Pollution, appointed by the central government under Section 3 of the Water Prevention and Control of Pollution Act 1974, Sect of 1974. Clause C. A representative of the Central Board for the Prevention and Control of Air Pollution, referred to in Section 3 of the Air Prevention and Control of Pollution Act 1981, 14th of 1981. Clause D. A representative of the State Board appointed under Section 4 of the Water Prevention and Control of Pollution Act 1974, 6th of 1974. E. A representative of the State Board for the Prevention and Control of Air Pollution, referred to in Section 5 of the Air Prevention and Control of Pollution Act 1981, 14th of 1981. Clause F. A representative of the Department of Environment in the state. Clause G. A representative of the Meteorological Department of the Government of India. Clause H. An expert in the field of occupational health. And Clause I. A representative of the Town Planning Department of the state government, and not more than 5 other members who may be co-opted by the state government, who shall be: number 1. A scientist having specialized knowledge of the hazardous process which will be involved in the factory. Subclause 2. A representative of the local authority within whose jurisdiction the factory is to be established. And subclause 3. Not more than 3 other persons as deemed fit by the state government. Subsection 2. The Site Appraisal Committee shall examine an application for the establishment of a factory involving hazardous process and make its recommendation to the state government within a period of 90 days of the receipt of such application in the prescribed form. Subsection 3. Where any process relates to a factory owned or controlled by the central government or to a corporation or a company owned or controlled by the central government, the state government shall co-opt in the site appraisal committee a representative nominated by the central government as a member of that committee. Subsection 4. The site appraisal committee shall have power to call for any information from the person making an application for the establishment or expansion of a factory involving a hazardous process. Subsection 5. Where the state government has granted approval to an application for the establishment or expansion of a factory involving a hazardous process, it shall not be necessary for an application to obtain a further approval from the central board or the state board established under the Water Prevention and Control of Pollution Act 1974, 6 of 1974 and the Air Prevention and Control of Pollution Act 1981, 14 of 1981. Section 41B. Compulsory disclosure of information by the occupier. Subsection 1. The occupier of every factory involving a hazardous process shall disclose in the manner prescribed all information regarding dangers, including health hazards, and the measures to overcome such hazards arising from the exposure to or handling of the materials or substances in the manufacture, transportation, storage, and other processes to the workers employed in the factory, the chief inspector, the local authority within whose jurisdiction the factory is situated, and the general public in the vicinity. Subsection 2. The occupier shall, at the time of registering the factory involving a hazardous process, lay down a detailed policy with respect to the health and safety of the workers employed therein and intimate such policy to the chief inspector and the local authority, and thereafter at such intervals as may be prescribed inform the chief inspector and the local authority of any change made in the said policy. Subsection 3. The information furnished under subsection 1 shall include accurate information as to the quantity, specifications, and other characteristics of wastage and the manner of their disposal. Subsection 4. Every occupier shall, with the approval of the chief inspector, draw up an on-site emergency plan and detailed disaster control measures for his factory and make known to the workers employed therein and to the general public living in the vicinity of the factory the safety measures required to be taken in the event of an accident taking place. Subsection 5. Every occupier of a factory shall, clause A, if such factory engage in a hazardous process on the commencement of the Factories Amendment Act 1987 within a period of 30 days of such commencement, and clause B, if such factory proposes to engage in a hazardous process at any time after such commencement within a period of 30 days before the commencement of such process, inform the chief inspector of the nature and details of the process in such form and in such manner as may be prescribed. Subsection 6. Where any occupier of a factory contravenes the provisions of subsection 5, the license issued under section 6 to such factory shall, notwithstanding any penalty to which the occupier of factory shall be subjected to under the provisions of this act, be liable for cancellation. Subsection 7. The occupier of a factory involving a hazardous process shall, with the previous approval of the chief inspector, lay down measures for the handling, usage, transportation and storage of hazardous substances inside the factory premises, and disposal of such substances outside the factory premises, and publicize them in the manner prescribed among the workers and the general public living in the vicinity. Section 41C. Specific responsibility of the occupier in relation to hazardous processes. Every occupier of a factory involving any hazardous process shall a. Maintain accurate and up-to-date health records, or as the case may be, medical records of the workers in the factory who are exposed to any chemical, toxic or any other harmful substances which are manufactured, stored, handled or transported, and such records shall be accessible to the workers subject to such conditions as may be prescribed. Clause B. Appoint persons who possess qualifications and experience in handling hazardous substances and are competent to supervise such handling within the factory and to provide at the working place all the necessary facilities for protecting the workers in the manner prescribed, provided that where any question arises as to the qualifications and experience of a person so appointed, the decision of the chief inspector shall be final. Clause C. Provide for medical examination of every worker. Subclause A. Before such worker is assigned to a job involving the handling of or working with a hazardous substance, and subclause B. While continuing in such job and after he has ceased to work in such job at intervals not exceeding 12 months in such manner as may be prescribed. Section 41D. Power of central government to appoint inquiry committee. Subsection 1. The central government may, in the event of the occurrence of an extraordinary situation involving a factory engaged in a hazardous process, appoint an inquiry committee to inquire into the standards of health and safety observed in the factory with a view to finding out the causes of any failure or neglect in the adoption of any measures or standards prescribed for the health and safety of the workers employed in the factory or the general public affected or likely to be affected due to such failure or neglect, and for the prevention and recurrence of such extraordinary situations in future in such factory or elsewhere. Subsection 2. The committee appointed under subsection 1 shall consist of a chairman and 2 other members, and the terms of reference of the committee and the tenure of office of its members shall be such as may be determined by the central government according to the requirements of the situation. Subsection 3. The recommendations of the committee shall be advisory in the nature. Section 41E. Emergency standards. Subsection 1. Where the central government is satisfied that no standards of safety have been prescribed in respect of a hazardous process or class of hazardous processes, or where the standards so prescribed are inadequate, it may direct the Director General of Factory Advice Service and Labor Institutes or any institution specialized in matters relating to standards of safety in hazardous processes to lay down emergency standards for enforcement of suitable standards in respect of such hazardous processes. Subsection 2. The emergency standards laid down under subsection 1 shall, until they are incorporated in the rules made under this Act, be enforceable and have the same effect as if they had been incorporated in the rules made under this Act. Section 41F. Permissible limits of exposure of chemical and toxic substances. Subsection 1. The maximum permissible thresholds limits of exposure of chemical and toxic substances in manufacturing processes, whether hazardous or otherwise, in any factory shall be of the value indicated in the second schedule. Subsection 2. The central government may, at any time, for the purpose of giving effect to any scientific proof obtained from specialized institutions or experts in the field by notification in the official gazette, make suitable changes in the said schedule. Section 41G. Workers' participation in safety management. Subsection 1. The occupier shall, in every factory where a hazardous process takes place or where hazardous substances are used or handled, set up a safety committee consisting of equal number of representatives of workers and management to promote cooperation between the workers and the management in maintaining proper safety and health at work, and to review periodically the measures taken in that behalf, provided that the state government may, by order in writing and for reasons to be recorded, exempt the occupier of any factory or class of factories from setting up such committee. Subsection 2. The composition of the safety committee, the tenure of office of its members, and their rights and duties shall be such as may be prescribed. Section 41H. Right of workers to warn about imminent danger. Subsection 1. Where workers employed in any factory engaged in a hazardous process have reasonable apprehension that there is a likelihood of imminent danger to their lives or health due to any accident, they may bring the same to the notice of the occupier, agent, manager, or any other person who is in charge of the factory or the process concerned, directly or through their representatives in the safety committee, and simultaneously bring the same to the notice of the inspector. Subsection 2. It shall be the duty of such occupier, agent, manager, or the person in charge of the factory or process to take immediate remedial action if he is satisfied about the existence of such imminent danger, and send a report forthwith of the action taken to the nearest inspector. Subsection 3. If the occupier, agent, manager, or the person in charge referred to in subsection 2 is not satisfied about the existence of any imminent danger as apprehended by the workers, he shall nevertheless refer the matter forthwith to the nearest inspector, whose decision on the question of the existence of such imminent danger shall be final.